Good morning, everyone. I want to thank you for attending this month's edition of the ARA Continuing Education Program. I want to, some of the rules, if you'll, if in the control panel to your right on your screen, there's a question box. After the presentation today or during the presentation, if you've got questions or comments you'd like to make that we can answer, we'll have some time at the end of the show. To do that, we appreciate you attending today. We thank you. We want to introduce Amy Holbrook with Weltman, Weinberg, and Reese. For those of you on our side of the industry, you may not be real familiar with the firm. They've been a friend of ours for a long time across the industry. They've helped a lot of my members in different situations. Mike Doherty, back in the couple of years ago, helped us a lot with our compliance pieces. So, you know, we run into each other a lot of shows and do a lot of things and trying to work together to come together on programs like this in the future. I hope that you find it useful and informational. I know that Amy will do a great job. She's done a lot. I've read a lot of what she's done, and she's helped me with a couple of projects before. So I want to welcome Amy. Amy, you're in control. Thank you very much for your time today, and thank you for your firm allowing you to be with us.
The opportunity to come here today and to talk to you about the world that we are currently living in, which is sort of new for all of us. I welcome questions throughout. I have a helper with me today who's making sure that if you chat up a question, I can get to it and answer it in real time. But I think the best seminars are the ones where we have some degree of conversation and we can sort of talk about the issues as we go through them. So with all of that, I also want to say thank you to all of you for making time today in your schedule to log in and to listen and to hopefully ask some good questions. So we'll get started. Today we're going to cover something that's fairly relevant to the time that we're in right now. We're going to talk about Replevin procedure, which is what my practice is centered on for probably the last 15 years. And in particular, we're going to talk about emergency Replevin. The reason those are critical right now is that with courts closing and with limitations on repossessions in some of our states, most, if not all, courts are now allowing emergency Replevins to be done. They're a very statute-specific way of doing things. They're a little different from what you see in your standard Replevin, so it'll be a good thing for us to talk about. The other thing we're going to talk about today is artisan liens and forfeiture problems. Because despite the pandemic, we're still seeing vehicles turn up in repair shops and impound lots, or we're still getting notices from law enforcement that vehicles are being held. We'll talk a little bit about bankruptcy because most estimates are that after this is concluded, we're going to see a rise in bankruptcy cases. And at the very end, we're going to talk about how these pandemic-related orders are impacting some of the repossession and Replevin efforts. So we'll start with just a basic overview of procedure. What a Replevin really is, emergency or otherwise, is sort of the layman's term for a court-ordered repossession. It's what, when people ask me what I do who aren't in our field, it's what I sort of tell them so they know what it is I do. It's an old way of practicing law. It's been around for a very long time in one form or another, and it's available in all 50 states. These court-ordered repossessions, too, are done in conjunction with repossession agents and law enforcement. A constable or a sheriff is our usual kind of teammate in these, but they're separate and apart from what's sort of standard. So I think I'm funny. I made up a little anagram here of what we need to do a good Replevin. We are always looking for, as attorneys, your repo findings. We want to understand what happened prior to when we got involved in the case. We want to know how the defendants behaved, because I tell everyone who's ever worked with me that not one of the defendants I sue is an easy person to get along with. If they were, I wouldn't have been retained to help the agents and to help the clients get the collateral back. But I want to know how they behaved. I want to know when the last time was that we've seen our collateral, where was it located, what kind of building was it in, and I want to know who's involved. I know it's going to be the consumer or the borrower, but was there anybody else involved? A girlfriend, a mother, a husband, I want to know the details because it helps drive the case and make it timely and efficient. I'd also always remind people that a lot of times we're sending out repossession, or we're sending out special process servers to serve these documents. So the reason I want to know that debtor's disposition is I want to know what I'm sending my process server into. Is this someone who's angry and violent? Is this someone who tried to run over the agent? I've heard those stories. I want to know that so that I can prepare my case in the best possible way. We're going to want evidence of the debt or lien. This is judicially required. I'm going to need a copy of the documents that secure our client's interest in how we're going to get this collateral back. I'm going to want to know about the parties in possession. The slam dunk answer is always going to be it was the debtor, but sometimes it's not the debtor. Sometimes the person in possession is the straw purchaser, that person who took over the loan because their cousin couldn't pay for it, or it's the new husband, or it's the old girlfriend. It's just really, we want to know who has the collateral. We want to know location information. The world in which we live is driven by a lot of statutory demands, and jurisdiction is one of the most important things we have when your attorney gets ready to file your Replevin. We want to make sure that we're in the jurisdiction where the collateral is located. If we're suing for money, which you can do sometimes on a Replevin, I've got FDCPA concerns. The FDCPA says that I can only sue someone where they live or where the loan originated. So if my car is in one county, but my debtor is in another, and the loan originated in another, there is an internal discussion we have to have about where best to sue this. Also, I don't like wasting people's time. If we know where this collateral is, then there's some steps we can take to make sure our Replevin goes smoothly. I want evidence of default. I want to know why I'm being retained. Most of the time, 95% of the time, it's going to be a lack of payment. But sometimes it's other things. Sometimes it's improper use of collateral, especially high-end or heavy equipment collateral. If it's supposed to be used for commercial use and it's not, then we've got a breach for some reason. If there's a lack of insurance, but I need to know the reason I've been retained and the reason we're entitled to take it back. I want to know the value. It's a court requirement. I need to understand what your collateral is worth. And for most of you doing general vehicle Replevins, that's really easy. You get me the NEDA values. But for specialty equipment, that's more challenging. For heavy equipment, it can be challenging. For things like, I've been retained to get back gemstones, I need to know the value of those. It goes into the court documents. It's going to set our bond down the road. So knowing that helps me do my job. I'm going to want identifying information. Remember, I'm sending out a sheriff, and I might be sending out one of your agents to go pick this up. What does it look like? What's the color? If you can get me a picture of heavy equipment, that helps me send our sheriffs and our constables out in a way that gets the collateral back faster. And finally, I want the numbers. I want to know how many missed payments. I want to know what the balance is. I better be able to figure out the due date, and I'm probably going to want your payment history because the judges are going to ask me questions, and I want to give them good answers. So the documents, they're the standard things I want you to think about. The reason we want these is this is an early flag to if a case is going to have issues. So was the contract properly signed? Is the commercial entity a business that exists according to the state we're in? Were there co-buyers? If there's an assignment, is the titling been done properly? I want to know if your security agreement properly identifies the collateral. Those giant long VIN numbers get interposed on a regular basis. So I want to know that we don't have any issues before we walk into the court. And this is where we find out if liens are notated correctly. It's an unfortunate case when something comes over and it turns out the lien wasn't notated and we can fix it, but identifying it early is important. And any kind of related assignment backs. So if this is purchase paper, I've got to make sure I can prove to a court that we have standing to be in front of them to bring this action. Why I care about your repo findings is, again, I can start to gauge pretty early on what our legal defenses are going to be in some of the cases where we've had problems. I want to know, is our defendant going to assert a breach of peace? I want to know if there's been property damage. These are things that if we get in front of, we can prep a really good case for. I want to know how confident we are, too, about where this person resides, because service is key. I need to get these people served with legal documents, so I want to know that we for sure know that they live there. We care about hidden collateral and gated communities because there are motions to be filed in these cases. They're called break lock motions in most places that enable me to use law enforcement to break into a space, get our collateral, and then relock that space. Those are pretty special, and so if we know early on that we're going to face that issue, then we can start getting our ducks in a row to go forward. And I'm going to want to know, do I want to use the sheriff or do I want to use my process server? Do we want that the guy who I use all the time to go out there, or is there a risk to him that I need to be aware of to make sure we get good service and everyone's safe? The last three of these are really about speeding up the process in general. These are all things we can work around, but is the collateral somewhere other than where the defendant lives? It's going to drive service, and alternatively, it's going to drive where I send the sheriff. We don't want to waste the sheriff's time or the repossession agent's time by putting addresses in that aren't really where the collateral is located. We're also going to know, especially for mobile homes and modular dwellings that we can use a Replevin to regain, where's that mobile located? Is it in a park? Because if it's in a park, then I've got possibly another entity, which is going to be the park owner. Are there unpaid lot rents? Are there unpaid utilities? I also, with mobile home cases, want to be particularly careful about unpaid property tax. With mobile home cases, if they haven't paid their property tax, there's a chance there's a tax lien, which will trump our lien. And what we don't want to do is invest in a Replevin, spend unnecessary money, and then find out we've taken collateral that really needs to go to the taxing entity. Also, I want to know if the only place we know where the defendant is his place of employment. I can serve someone at their place of employment under certain circumstances. We have FDCPA concerns about this, and that we don't want to disclose to any third parties about a debt, even if it's service. But if we can get to that defendant at his place of employment and have him served directly, not through a secretary, not through a supervisor, then there are some things we can do. Knowing the party in possession helps us get an order for the lender and the agent for quicker recovery. So again, who's got care, custody, and control over the collateral? This might include landlords. It could include owners of property who are not your defendant. The best example of that is if you have a defendant and he is a renter and he leaves your collateral, let's say it's a motorcycle, parked in the garage of his apartment, and then he's evicted. He's your liable party for the debt, but to get into that garage where that motorcycle is located, I've got to use the landlord's name. So I want to know who that's going to be. Who am I going to name, and maybe who do we reach out to and avoid the Replevin altogether? If the party in possession is a business, we care about that for the reason that the courts are going to require service. Now, the vehicle might be located at the place where the business operates on Main Street, Ohio. But the person I need to serve is the attorney he hired in Indiana. So I'll have to serve in Indiana, but I'm going to direct my sheriff and I'm going to file in Ohio where my collateral is located. Multiple parties can be involved in a possession count on a case. But again, we want to know this for jurisdictional reasons, for sheriff reasons, and for FDCPA concerns. And then we go to evidence of default. I want that payment history. And if you receive something from insurance indicating the insurance is default, I just need to know how you knew. How did you know that that default occurred? If it was improper use of the collateral too, I'm going to want to know how you know. And likely it was your agent who saw that. Your repo agent most likely saw the collateral in use, or you got a call from a third party. We just need to document how it is we're going to call that loan in default. As mentioned before, this value of collateral determines your bond. So you're helping your attorney so that you can get your Replevin filed faster. Unusual collateral is more difficult. I think the strangest thing I saw was a bike that someone had done a lot of custom work to, and we had to value what it was going to sell for, which was not easy, and it took a little bit of time. Standard vehicles, this will be really easy. Why do you file a replevin? Like I said, 90% of the time it's because the defendants acted up during the course of self-help. Sometimes it's because it's locked behind doors or locks that you can't get through, but it's generally because someone is not allowing it to happen. Why would you file an emergency replevin? These are those special replevins that we can still get through even in places like Illinois, where there's a bar on repossession and the courts aren't accepting replevin filings. They'll still allow an emergency case to be filed. Emergency cases are generally used whenever a defendant says that they're going to damage collateral in a way that diminishes its value significantly. So I gave you a picture of a Dodge Viper. This is one that somebody set fire to in order so that it wouldn't be repossessed. There are some things you need to know, though, because not all cases where a defendant has prevented self-help are good cases for an emergency. Emergency cases are generally for when there's danger to the collateral, which usually means they're going to dismantle it, they're going to destroy it, or transfer it out of jurisdiction. Look, these are simple to identify. Certainly the guy who says he's going to dismantle his motorcycle before he'll let you have it back, you've got grounds there. Transfer sometimes means transfer from the jurisdiction. The best example I have of this was that gemstone case. We got involved in it because there were loose gemstones at a jeweler. He had used them for security for a loan. And then we had good reason to believe through a third party that he was packaging those gemstones and shipping them to Mexico where his brother lived. So we did an emergency replevin on the grounds that he was transferring our asset beyond our reach. So that's a good example of concealment or of transfer. The other one we see up here up north in Ohio are people who want to float their boats to Canada. If we get word of that, then we can oftentimes get an emergency replevin. It is our burden when we file these, and that burden will vary state to state. There are pros and cons to this whole procedure. One is the cost. They generally tend to be a little more expensive. The benefit, however, is that they're fast and that results tend to be very quick. You are going to have to post a bond for these just like you would in a normal case. It's 1 to 2 times the value of the collateral. Collateral value can be a statutory term, meaning you have to take it from a certain place, but generally, as the moving party, the plaintiff gets to set how they use the bond or how they're going to set that value. Also, once you get back possession of collateral through this motion that we file, this motion for possession, you are generally obliged to complete your case, meaning you got it back, you cannot dismiss until you have a final judgment from the court. So both of these start in sort of the same way, both an emergency replevin and a standard replevin. They start with the filing of a complaint and a motion. Both motions are supported by affidavits. The difference really in the procedure for these is the affidavit itself. So the affidavits are similar in some way. We need to explain to the court, how does the defendant get possession? That's simple in most cases. We lend the money to buy a vehicle, and they purchase the vehicle, and they have possession. It gets more complicated in third-party cases, where there's been another transaction beyond your reach. We use that in order to set up the affidavit and explain that, unbeknownst to the creditor, a secondary agreement was reached between our defendant and a third party. But we have to lay out for the court how the defendant came into possession. We have to tell them why the possession is wrongful, that there was a breach, that there was improper use, that it was given to someone else without our authority. We have to lay it out for the court. We also have to tell them how the property is being used. Is it business, personal, or both? Sometimes we don't know, so we say both. Most of the time it's personal. The volume of cases are personal, but there are plenty of business cases too. We've got to give the court an idea of where our property is located. Now, a lot of my clients get really hung up on this. They're like, well, what if it's not there? It is at the time of filing where we most and best believe our collateral is located. We've got to tell them how much will be damaged. Clients get caught up on this a little bit. Damage, for the sake of a replevin, is not how much you're owed under the loan. It is the value of your collateral. Again, why valuation is really important, because we're telling the court how much will be damaged if we don't get our collateral back. And then we have to offer the court reassurance. We have to tell them that there's no superior lien interest on our collateral that would impede our right to take it back. And that's our seizure cases, that's our tax and fines, those kinds of things that are out there. So what you care about as my client when you file a replevin is this possession hearing. It's the hearing on the motion for possession that generally gets filed at the same time as the complaint. If you've worked with me before, and there are several of you on the call who have worked with me over the years, you know that when we file that motion, a hearing is generally set about 20 days from the date of filing. So the name of the game after we file our case is service. So we want to get that case filed, we want to get our sheriff or our process server out and get service before that 20-day hearing comes up, because that's when our motion, that's when our right to take back collateral is going to be heard. For emergency cases, things are a lot different. The motion's granted at the time of filing. So if any of you have worked with me, you've probably heard me sigh heavily, because it means I have to stop everything and get your motion, get your complaint ready, and then I have to literally walk it through the court most of the time. And it's true for most states too. These are instantaneous motions. So we're going out to the court, we're saying our collateral is so in jeopardy that we don't even have to serve the defendant. We want our collateral now before he or she destroys it. So there's still a hearing, but it is set after the motion is granted and after the bond is filed. So service. You heard me say it before, I care deeply about service. A big portion of my job as your Replevin lawyer is making sure I get good service timely. I'm supposed to perfect service 7 to 10 days prior to that 20-day hearing date, which means I'm getting sometimes 10 days to get service perfected. Why I really want good addresses, I really want to know what your collection notes say, I want to know what your repo findings are, because the name of the game to move your case quickly is to get that defendant served. Now with the emergency replevin, I'm still going to have service, but that service isn't driven by that hearing date. Instead, I'm going to have to perfect. Also, if I get the collateral back, 9 times out of 10, service is going to be simple, because we know where that defendant is. I've already sent the sheriff out, picked up your car, we've probably made him pretty angry, and he's probably calling me on the phone. So we're going to get service on those cases, but that time constraint is a little lighter. As a pandemic issue, courts are still somewhat delaying replevin hearings. I can see in my own practice, although they are conducting them, sometimes by Zoom, sometimes in person even, but the emergency cases are still being heard and are fairly timely right now. So for those, I don't think we're going to have as many issues. So hearing dates sometimes don't go forward. They sometimes only go forward if the defendants request them. This is a jurisdictional issue. When the defendant gets served with that complaint and that motion, they also get what's called a hearing request form, where they can request a chance to be heard. And they can request that in an emergency case and a standard case. The hearing dates get set, and if the defendants request them, they're definitely going forward. By jurisdiction, courts sometimes require they go forward regardless if the defendant has asked for them. The standard at a replevin hearing, be it an emergency case or a regular case, is a probable cause. So for my Law and Order fans, that just means it has to be more likely than not that the lender would be successful if the case proceeded to final judgment. And I want you to always remember that these orders of possession are granted. And when they're granted, they take away a consumer or a defendant's property rights. We view that as a pretty serious infringement of rights. So the reason that that's our standard is I need to prove to the court that we have good reason to take something back. Those hearings can be on the record, meaning that there's a court reporter there and everything is being recorded. Sometimes they're done in a judge's chambers. And those hearings offer a unique chance when the defendants do appear. Oftentimes there's a chance of getting a resolution or working out a solution. Sometimes it's a matter of, I meant to surrender this, but I didn't. A lot of times people don't take things as seriously until after they've been served by maybe a sheriff and they've had to come in front of a judge. A lot of times we can work out a deal where they're going to leave the collateral somewhere or drop it off somewhere so that you can get your collateral back. It's also an excellent time if a case is going to become contested to get to hear their defenses. We want to hear what they're going to raise. It's going to drag the case out, and any chance I get to talk one-on-one with the defendant is a good thing. It is a time when I can hear them tell me sort of their side of the story and see how willing they are to work. I usually tell defendants my clients are usually way more interested in getting paid than they are in taking back cars. And a lot of times people want to work a deal. And sometimes there's really good stories to be heard about what happened, what's going on. And there may be times you, my clients out there, will have to come with me. It's fairly rare, but there are a handful of times, especially on cases that are hotly contested, where you may be required to come to a Replevin hearing and sit in front of a judge and explain a default. So when we win our motion for possession, we are allowed to take back the collateral that's outstanding. But before we do so, we have to post a bond. And again, it goes back to that importance of value. Bond is generally set at twice the value of the collateral. So we care about this because you have to post that bond before you can issue the writ. The writ is what sends the sheriff out to go get your collateral. And we care about it too because the defendant could in fact post that bond and keep your collateral. So I'll give you the example. If I was going to repossess a Dodge Durango and I valued it at $2 because I didn't want to post the bond, like a very high bond, I only have to post $4. But unfortunately, then the defendant could come in and say, I'm going to post the bond at $4 too. And then he gets to keep it and he can post it anytime. The bonds are usually, they're held by the clerk of courts. A lot of my clients get their own bonds. However, your lawyer or Weltman should be or can get your bonds for you. And we post the bonds and we leave them with the clerk. The clerk holds them until the end of the case. Usually at the final order, you'll see go through on a case. It'll say the requirement of bond is hereby waived. That's the note to the clerk to send it back. If for some reason the clerk doesn't send it back, there's the method for getting it back. We just file a motion and have it done. What is a writ? Writ is a fancy word for instruction. You may have seen the word precipice. Precipice is another fancy word for request. We file a precipice for writ, meaning a request that the clerk send the sheriff out to pick up our collateral. That's the mechanism, the enforcement mechanism on a Replevin action. Those writs are generally valid for 180 days. The sheriff has a lot of discretion about how often he goes out. He may elect to go out and 4 times. He can elect to go out 3. If most of the sheriffs are really good about telling us, like, look, I went out and the house is vacant. He's not going to keep going back to a vacant house. In the smaller parts of the world, the sheriffs are incredibly diligent in that they might go see his grandmother without my requesting it to ask where he's keeping the car. So those writs are the real strength and enforcement power behind a Replevin. Most of the time, how a writ really works is that the sheriff will either go out, find our collateral, and tag it, or he'll take it and take it to an impound lot. Then he notifies the agent to come pick it up. There are occasions when an agent is going to be called out to go with the sheriff. That's going to be mostly your emergency cases. So what will happen is when I go file it, the judge grants it, I post your bond, I file your writ, and then I'm going to walk over to the sheriff's department and I'm going to say, here's your agent's name and phone number for you to make arrangements to go out with him and pick it up. So they go very fast. On the normal Replevin, what will happen is I'll file the writ with your agent's name on it so that the sheriff knows when he either tags it or whenever he picks it up himself, who to call. If he can't reach your agent, he's going to call me, and then I'm going to have to hustle and call the client. So make sure that we all it's always good that we all work together. One thing I want you to take away from this, if it's heavy equipment or specialized equipment, stuff that's bolted to the floor, stuff that can't be moved in a standard fashion, the burden of the cost of its removal will fall on the plaintiff or the lender. So that means for I'm trying to think of the best example. I had a tire recycling machine that was bolted to the floor of a factory in Cleveland. We had to pay to have it removed. Another good example is an MRI machine that we took back. The MRI machine, a room had been built around it. So they had placed it and then created a examination room around it after it had been placed. We had to pay a construction company to pull it out for us. So if you've got unusual equipment, heavy equipment, I think I had a banking client once, asked me to take back a hot tub, and the hot tub had been built into a deck. Now, this was a very expensive hot tub, and a crane had to be obtained so that they could pull it out. So those are things with unusual cases to sort of bear in mind. It's easy to focus on the simplicity of a general Replevin, but there are complicating issues. Mobile homes can be complicated. I've seen ones where they're either hard to move or alternatively they're stuck in mud, or we have to do something to get them out. So we want to make sure that we've got the agents lined up and the skill sets available to get our property going. So here we are at final judgment. Usually we obtain that through a motion for default judgment or a motion for summary judgment. Occasionally things proceed to trial and we get judgment that way. That's when your permanent right of possession is granted, meaning it's yours for good forever, no bond required, and that bond comes back to you. Also, that's the time when any wrongful retention for the taking, so let's say a ne'er-do-well filed a Replevin and took someone's car away, and they lost at trial. That bond you posted, that bond is there to protect the consumer or the defendant in case we were the party that was doing something wrongful through the court. I can say in my 15 years, I've never had that happen, but I understand the necessity of having that money sit there. Also, the costs of the action are awarded to either party. And one thing to really keep in mind is there are going to be occasions when you can't regain your collateral. It will either have been destroyed by a third party, it may have vanished, particularly with things that are UCC secured, meaning not certificate of title secured. You do have a claim for conversion, and almost every state allows you to convert a Replevin claim to a conversion claim. The thing to bear in mind is conversion claims are only as valuable as the collateral. So if your Dodge Durango, again, was involved in an auto accident and was only worth $2,000, when a storage company either smashed it or flipped the title on it, you're only entitled to what it was worth. You're not entitled to the Durango's NADA. And a few post-judgment things to think about are the motion to show cause. So that final order of possession will actually say that the defendant is ordered to surrender the collateral. That is in both an emergency case and a standard case. If we're unable to recover it and we do not believe it was destroyed, we can file a show cause order in front of a judge. And a show cause order is a fancy way of saying contempt because the defendant has not done what the court ordered him to do. So we can file a show cause motion and have him appear before the court to explain why it is he doesn't think he should have to adhere to the court's order. There are also some post-judgment executions. There's always a post-judgment debtor's exam. Those are on hold in a lot of jurisdictions because of the pandemic, but they'll be back. If you were able to obtain a money judgment, you can do a wage garnishment. Nothing gets anyone's attention quite like garnishing anyone's wages. And you can also ask for a bench warrant off of that show cause. A bench warrant's not like your law and order criminal citation. Instead, it is if he gets picked up on a traffic violation or other criminal offense, the court can hold him and allow us the time to talk to him about where our collateral is located. I put in a couple of third-party issues for consideration. The first is Artisans Lien, which I think is maybe the weirdest name for some of the things we see. But an artisan lien is really a lien on collateral for work generally done by a repair shop, meaning they've added value in some way. Related to those are storage liens. We see those a lot whenever I take my car to the shop to get the transmission fixed. I don't pay the mechanic and I just leave it there. And then we see right now a fair amount of impoundments, forfeitures, and immobilization. Those are the ones that are probably the most consistently complicated that we see come in and out. So what is an artisan's lien? The notion is that the guy who fixed your car does add value to the vehicle in some form or fashion. In some states, so that is a possessory lien. So as long as he holds on to that vehicle, he has a lien on it for his work that he has put into it. In some states, Michigan, for example, that artisan's lien supersedes other liens. Here in Ohio, where I'm at, their liens are actually secondary. And sometimes, some states will allow you to put in storage fees. So what you'll see is, I fixed the transmission, that was $2,000, and here's another $5,000 in storage fees. This is extremely state specific. So when you get notification that you've got one of these, it's important that you contact your attorney or get some legal advice. There are notification requirements for these liens. So I shouldn't be holding a car for 6 months on my lot before I notify you I have it. For as a lender on these, are you getting contacted by the repair shop? Are they calling in? Because 9 chances out of 10 that they're not getting paid either. And the promises of payment from our consumer are not coming, they're not following up with them either. So they're going to be looking at the bank or the lender or the credit union as the deep pocket to get their bill paid. With a debtor, you want to look for a sudden stop in payments. Have they given up trying to get their car back? And then, of course, I think for our credit union clients out there, the grapevine, has another member told you about the fact that some so-and-so left their car at some garage somewhere? Storage liens, like I said, sort of go hand in hand, but they are not related to an improvement in value. The thing that distinguishes the two of them when you're the person getting notification is, has there been added value to your collateral? Most states now, there is a split about if storage liens somehow supersede perfected. The tendency appears now to be that storage liens are inferior to perfected liens, depending on the reason why the vehicle was towed. If the vehicle was towed and stored related to a law enforcement order, those tend to be superior in that in order to get your car back, you're going to have to pay for the storage and towing. However, for cases where I took my car to Joe's transmission shop, didn't pay for the transmission, he never did any work, and now you're getting a bill for the amount of time the car was stored, those tend to not supersede the other liens. But again, when you get notification, get advice from legal counsel. These can vary jurisdiction to jurisdiction, state to state, so you want to make sure that you're paying attention to those. So again, find out why your vehicle was towed, who ordered it, is there a judicial do you need a judicial release to pick it up? Sometimes these vehicles are sitting on lots of private owners, but they're on a hold from a criminal matter, which means do you need to go back to that criminal court and find out how to get your vehicle back? And always ask yourself, was value added in these cases? Did the repair shop do work that made this more valuable, this car more valuable? If they did, they probably have a claim for something called unjust enrichment, meaning they put something into it for which you were going to get a gain as the secured lender when you sell it. If it's just stored, there's an argument to be made that there's no gain. Also, watch those daily storage fees. I have seen numbers that range anywhere from $10 a day, seems rather practical, to I think the highest was $75 a day. So we want to make sure that we're looking at those fees and seeing what's going on with those. Most states have sort of an agreed upon service argument we can make too. You didn't ask for the work to be done. Also, we want to make sure that if work was done to add value, that that work was well done, that the car is roadworthy. The best example I have is a case in which I litigated where a vehicle was involved in an accident. It was towed to a repair shop to have body work done. It turned out that the frame was bent on the vehicle. The repair shop then did work on the car, submitted a bill in excess of $8,000 and said the car was roadworthy. We did an auto inspection of the vehicle. The car was not roadworthy. We could not have sold it at auction. We were lucky enough to have a very good agent of ours come with us who does inspections. He was our expert at trial who testified to the fact that the vehicle wasn't roadworthy. We couldn't put it back out on the market, and so therefore we weren't paying their repair bill. They were going to have to cover some of our attorney fees. So it was a very good result for our client. But it's important that when you see these repair shop cases, these where work was done and value was possibly added, that you're doing an inspection to make sure that work was done correctly. These are just some really good points to ask yourself whenever you get one of these calls from someone about whether or not a vehicle you should be paying for a lien or should be negotiating. Was the request from a private entity? Was law enforcement involved? Oftentimes on these law enforcement cases, on these criminal cases, some courts are going to let you as the lender go in and file a motion or file a notice to get your vehicle back. But in some courts, they're not going to let you do that. You're going to have to retain counsel. When you get notification that a vehicle has been held pursuant to a criminal hold, you need to get advice or you need to be in contact with the court. Also, if you're going to handle this yourself, document internally very well who you're talking to. Remember, when you call the clerk of courts at a municipal court, they're not authorized to give you legal advice. So make sure when you're talking to them, you are documenting precisely what they say. It is too often where I have seen clients call, speak to a clerk of court in a criminal division, think they were doing the right thing, and then we lose a car entirely. So advice on these is always get legal advice. Do not rely on what a clerk is telling you. Also, as soon as something feels like it's going wrong, it probably is. So get advice, follow up, have a system in place for when notices of impound or seizure come in, that you know what to do with them and who to get them to, so that they're addressed quickly and efficiently. I've talked a lot about notices. Not all states require lien holder notification, but most do. So take away from this, just having that system in place for whenever it is you get the notice, what you're going to do. Also have a system in place for when you get that call in to your collector, or you get that call into the person handling the account saying that a repair shop or a law enforcement office is called in. Just have your systems in place because it's going to happen. If you're in auto lending, if you're in any kind of secured lending, something that you've got an interest in is going to come under scrutiny at some point. The most common of these, by the way, are DUIs when it comes to seizure and impound. There are states, mine is one of them, 2 DUIs in under 7 years, you automatically lose your car. So those can get fast and furiously complicated. You want to file what's called a motion of interested party inside of those so that you protect your interest and you get yourself notified of when that seizure or forfeiture is going to happen. A lot of times there's 2 ways these usually go. Either law enforcement auctions off and sells your vehicle, and then the proceeds are given back to you and excess goes to law enforcement, or the vehicle comes back to the lender. Some of these DUI statutes say that when you sell it then, as the lender at auction, you cannot sell it to the defendant or any direct relative of the defendant. One of the things you want to make sure of, because you've got notice requirements going out to the defendant. On some states, those sales are public and the defendant is allowed to appear. You need to get an order out of that criminal court that waives your requirement under the consumer protection so that you can sell that. If he should show up at auction, you are not permitted to sell it to him. That you don't have to worry about those consumer protections. Also, have your lawyers talk to the prosecutors. A lot of times, prosecutors don't see a lot of lien holders showing up. It turns out some people get their second DUI in under 7 years are driving older vehicles, so we don't have lien holders. These tend to throw prosecutors off slightly, so you want to make sure your lawyer's talking to the prosecutor make sure that your interest is being protected in that criminal case. Bankruptcy issues. We anticipate after this pandemic concludes, there's going to be a significant amount of action in the bankruptcy courts, unfortunately, and it's important to sort of have an understanding of how Replevin and bankruptcy sort of go hand in hand. Most of you are going to know that the minute a bankruptcy is filed by a defendant, an automatic stay goes into effect that prevents new actions, new state court actions from being filed, and it stays any pending state court actions. I tell my non-lawyer friends, it's like touching base when you play tag. Bankruptcy is base. You touch it, and then no one can tag you while you're on it. It's only temporary, and bankruptcy really means, and I think it's important to understand, the reason for the stay is that once the bankruptcy gets filed, the assets and liabilities of the defendant are temporarily transferred to the bankruptcy trustee for administration. So for a very brief period of time, all of his liabilities, all of his assets go to this person or this entity to administer and take care of. What the automatic stay really means is that for any pending Replevin we have, I'm going to file a notice of stay. And the reason I'm going to do that and not dismiss is when I file a stay motion with the state court, staying my Replevin, it enables me at some point, if you don't recover your collateral, or if you get a motion for relief from stay, I can go back in and lift it off, and you don't have to pay a second set of court costs. It saves you money in the long run. It also makes our cases go a little faster. Also, I don't have to perfect service a second time. So again, they file bankruptcy, we file stay. You also can't repossess, you can't foreclose, and you can't evict while someone's in bankruptcy stay. You can't levy against any property, and you can't notate a lien or title. So this is a really bad time to figure out that our lien wasn't properly notated, because while the bankruptcy stay is going on, there's not a lot I can do to that. From where I sit and from where you sit, no more collection letters. No more sending any of that off, and no more set off. Also, if you've got a letter program out there and where you're sending out Right Secure or notices of sale, you need to make sure you put bankruptcy language inside of those, because often those are referring to a debt, and once the bankruptcy stay is in effect, we've got entirely different sets of language that we need to use. I used to work for a bankruptcy court judge in another life. When I first was out of law school, I worked for a judge here in Cleveland. I can tell you firsthand, you do not want to violate a bankruptcy stay. It is strict liability. It is unpleasant for the lender. It is an embarrassing place to be. In all honesty, a lot of debtors bar people are going to give you some notice and let you fix it. But it doesn't matter if you were notified as a creditor. So even when they forget to list you, you are still governed by the stay. Remember, violation of that stay can expose you to huge amounts of fees and penalties, and those can be attorney's fees for the other side. And as a litigator, there's no worse thing to hear for your client is that they have to pay the other side's legal fees. We don't like it. So really, the bankruptcy court is not playing. When they put the stay in there, it's serious, and the ramifications for not following it are very strict. We talked about the stay. One thing to keep in mind, though, is the co-debtor issue. So in Chapter 13, that automatic stay goes into effect for any co-buyers too. And while that doesn't seem fair, right, that's not the bankrupt party, the reason that stay goes in is because under most Chapter 13 plans, you're going to get some form of payment. So that means the co-debtor is protected under the bankrupt debtor's bankruptcy. Now, there are ways to get around that. You can get relief from a debtor's stay by filing the appropriate motion with the court, especially if the debtor's plan, that bankrupt debtor, doesn't have 100% payments going to the creditor. You've got to show that the co-debtor received consideration for the debt, meaning access to the collateral, money lent to them, some kind of benefit. And that this co-debtor stay would cause irreparable harm, meaning your inability to recover that collateral or that inability to even collect money from the non-bankrupt debtor is going to harm the creditor. If you repossess a car and someone files bankruptcy, you're probably going to have to take it back, and you're probably going to take it back at the creditor's expense. So the way to get back in the game in a Replevin case is to do a motion for relief from stay. It's the best recourse for my clients to get back into the world of Replevin, getting back their collateral. I'd ask you to remember that even relief from stay, though, doesn't let you resume collection on the debt. It only lets you resume your actions to get back your collateral. I actually asked my bankruptcy team on this because I wanted to know, in the world of the pandemic, how the courts are handling these. It appears that they're still pretty timely heard, even in the midst of all of this. The motions are generally heard within 30, and the rulings are out within 6 weeks. So that's pretty average from what I'm hearing, so there's been no real slowdown in the bankruptcy court regarding how these are going forward. Motions for relief are evaluated on a pretty strict standard. There has to be a lack of payments coming into the lender, meaning they're not getting any adequate protection payments, nothing to protect their interest in collateral or their lien position. The debtor can't or should not have equity in the property. The reason for that equity is an issue of, is the property going to be an asset of the estate, something that could be sold, cure your lien, and be used to pay other creditors. And that the property is not actually necessary for an effective reorganization in this 13. This property isn't there so reliant upon it that it's going to cause the plan to fall apart. Sometimes you will not have us file a motion for relief from stay, and we'll wait for discharge. Often that's what's going to happen in Chapter 7 case, because they tend to travel through liquidation. So that debtor discharge will go into effect. The stay becomes permanent as to the debt, but it does not remain permanent as to the lien position. So while I can't go after them for the amount that you're out, I can reactivate a Replevin case that's being pursued for money and for possession, dismiss as to the money portion, and then pursue as to just the action for possession. Again, much like the notice of stay, the debtor's discharge is sanctionable. If you do not adhere to the court's order, it is not a good thing. I wanted to talk quickly about repossession letters. One, these are incredibly state law driven. These are governed by each state. I like to think my home state of Ohio has made them incredibly complicated. But some of the things I want you to keep in mind in the terms of the pandemic is, let's talk about notice of sale and right to cure. They're often governed by different time frames. So you may have 20 days from the date of repo to get out the right to cure. But the notice of sale has to go out no more than 20 days before the sale. We live in a world in which sales are not happening timely because of the pandemic, because we want to get good prices for collateral that goes to sale. So a lot of states are going to allow you to pull those two letters apart. I've seen a lot of you combine notice of sale and right to cure. I would encourage you, if you're doing that, to be really cognizant of those deadlines. When do those letters have to go out? What is the drop dead for these letters? Because I sense and I anticipate seeing cases now where letters are done wrong, because we're still sending out the same old letter, but our cars aren't selling in the same time frame. So again, watch your timing. Also watch your, make sure your notice of deficiency and surplus letters are going out. It seems to be a thing now. I haven't seen it in a long time, and I've seen a ton of it recently. Every state requires that a letter go out explaining after a sale that a vehicle sold is sold for this, and this is what's owed, or this is the surplus coming back to you. In most states, failure to send that letter is a de minimis fine. It's not very much, but you shouldn't start your collection until you've sent the letter. In some states, it's much more harsh, and I'm thinking it's Massachusetts was the last one I read that has a very harsh, you can't collect at all if this letter doesn't go out, and there are fines and penalties that go with it. So make sure that your letters are going out and that your deficiency letters are going out. So if you fail to do this correctly, many of you know this, It's often a waiver of your deficiency balance. So you're going to be out money from the sale, which means that you've sold the collateral, and that's the best it's going to get. You're not going to be able to collect it all. There may be an independent cause of action, either in the form of a counterclaim when you file your collection suit, or from a defendant who's just going to give you a ring and hire a lawyer and sue you. And then the worst case scenario, the ones I hate to see for my clients, are the class actions, where there is a systemic issue with your letters. The letters aren't going out timely. You've overlooked co-debtors, addresses are wrong, sale dates are wrong. One of the big ones on class actions is public and private sales. Some states let you specify if it's a public or private. If it's a public sale, though, it must be listed as public. And if it's a private sale, it must be listed as private. Mixing and matching those will not work. The laws are pretty strict on these, and what you don't want to have is a systemic issue. And the last thing I wanted to talk about briefly was just some of the pandemic considerations that are out there. We talked a lot about this. There are bars on repossessions in a number of states now. Voluntary surrenders are overlooked or are allowed in a lot of them, but not all of them. Whenever I get a chance, I've been talking to anyone in legislation that will listen, that to make sure that voluntary surrenders are allowed, to make sure that people can still call an agent and give their car back. It's in everyone's best interest, for the person who does not want to keep their vehicle, to get it back to the lender, to the agent, and get it sold and back out of the market and get the maximum value for it. One of the other things I think we're struggling with in particular is service. The pandemic has limited the sheriffs that are willing to go out and do service. Some states are, like Illinois and Pennsylvania, sheriff serves everything. So we are seeing service. I did have an interesting case recently with a judge during the pandemic where I had an order of possession and we were uncertain if an agent could go out, and the judge actually put on an order clarifying this was not repossession, this was following through of a judicial order. So I encourage your lawyers to be thoughtful about pressing these where they're barred from doing them. We're going to do another seminar, our colleague and I are, about some things we have concerns about commercial reasonableness in the midst of the pandemic. We've seen clients selling collateral online in ways that would not be the standard ways of selling collateral. I think, and we do not know this, but I think you're going to see some litigation about what vehicles are going for in these unusual sales. And we saw this before. Whenever online sales first started, clients wanted to sell vehicles on eBay. It's a really cautious way to travel, and we are probably a little conservative as a firm, but I would be very reluctant to enter into sales transactions or auctions that are not through your standard companies. Court hearings and courts, I can say that I anticipate most courts throughout the United States having a lot of reading on this to open mid-May. I just got word that Illinois extended its stay-at-home through the end of May. Massachusetts yesterday announced it's going to be closed through May 18. Be aware and watch your guidelines. In Ohio, it is every court for itself. So we are constantly watching our courts to see if we can judge when and how they're going to hear things. Most courts have moved fairly rapidly to electronic technology, but I think the legal and the court system is the slowest to change their minds. Les, do you want to tell them about the article or the spreadsheet you were made aware of this morning?
Yes. In CU Collector today, and it's NCLU, I think, is that right, Amy? It
is.
Creditor. They put out a list this morning of state regulations in states that were still withholding collection, court actions, or collection activities. This is, I did find an error because it didn't include Arizona, which has a 90-day hold starting March the 12th or March the 17th, but they were mostly up to date on the governor's filings, but in some states where attorney generals, I noticed that they weren't up to date on that. So it became a bit, I saw it this morning.
I found one too at nclc.org, and that's normally a pay site, but they have waived the requirement for having a membership in order to get this document, and they had a nice one, and they do have Arizona on theirs. So that's a good one too if you want to do some, if you want to look at some things.
Okay, great. I didn't know about that one. Did you see the questions?
No.
Okay, well, you got two questions if you got time real quick.
I do. Can you read them to me though? Because I can't see them off this thing.
One of the questions was, can I retain your firm for a vehicle located in Alabama?
We are not a location firm, but I'm sure you can connect them with people. I can certainly sue someone in Alabama, though, if you like.
Okay. Well, I know that you guys kind of help with some names sometimes, so that was just a question that came in.
Yeah, why don't we get that
if this person, okay, I will get it to you and we'll see what we can do.
Okay.
Next question. After forfeiture, can a law enforcement agency condition the release of collateral to a secured creditor upon the secured creditor's promise to disregard a consumer's statutory and contractual right to redeem the collateral?
Yes, but I would advise you on those. When you are in that situation, to make sure you get an order from that court so that you've got something in writing signed by a judge that says your consumer protection obligation has been waived. I would not want to go in front of a civil judge where a right to redeem or a right to cure has not been sent out, or we did not allow it, and we didn't have something from a judge in that criminal proceeding authorizing us to do so. Full faith and credit between the courts will let us as long as he puts it in writing, you don't have an evidentiary issue. You've proven that you didn't have to do it.
Okay, perfect. That's the only two questions I've got, Amy, and I think our hour's up. I want to thank you very much for the presentation today.
Oh, thank you all so much for giving me your time. I hope everyone, learned something or is willing to share something. Please email me if you do have questions, and I hope everyone stays well.
Everything. Thank you, everyone, for attending. If there's any questions that you have for ARA, please let me know right away or reach out to me, and I'll try to answer. And if anybody needs to ever reach Amy again, I'll be glad to refer. Thank you much, Amy. Good day.
Thank you so much.